Hello and welcome. We're thrilled to be hosting this year's 10th Symposium on HIV law and human rights and sharing the work of extraordinary advocates in Canada around the world who are fighting HIV criminalization. My name is Sandra Kahan-Chu. I'm the executive director of the HIV Legal Network, and I'm joined by my colleague and co-executive director, Janet Butler-McPhee. Before we begin, I'd like to take a few moments to share some housekeeping items. There's simultaneously French translation on the panels on Zoom. If you look at the bottom of your screen, the Zoom toolbar, there's a globe icon for interpretation. Please click on that for the French interpretation. And if you have any tech difficulties, please just put your questions in the chat and our colleagues are on standby to help you. We'll have 3 panels today, each tracing the evolution of HIV criminalization. And we'll start with the first 2 panels, and after the first 2 panels, we'll have a short break before the 3rd panel. So that's when you can take a little break, do what you need to do, get some water, etc. After each panel, we'll be doing a Q&A, and we invite you to type your questions in the Q&A section again, on the bottom of your screen. We will be monitoring that for your questions during the session and afterwards. If you'd like to chat, we invite you to also put your comments in the chat box. This session will be recorded, and a link to the symposium and the panelist presentations will be accessible after the event. And for those of you on social media, we invite you to use the hashtags HIV Criminalization and hashtags CDNPoly today. We'll put that also in the chat box for you to see. Now I'd like to turn it over to Janet to acknowledge and give thanks to the land on which we're hosting our webinar today.
We at the HIV Legal Network acknowledge that the land on which we live and work is traditionally known as Turtle Island and home to the Haudenosaunee, the Wendat, and the Anishinaabe, including the Mississaugas of the Credit First Nation. As settlers and as human rights advocates working for health and justice, we are called to honor the calls to action of the Truth and Reconciliation Commission in our work. But today we are coming together on this virtual platform from all across Turtle Island, the lands and unceded territories of many Indigenous groups and communities who have respected and cared for this land since time immemorial. We gather in this virtual space today to have critical conversations about HIV criminalization and its effects on people living with HIV on these lands. As people committed to addressing ongoing injustices and health inequities, we must recognize that many of these harms are the result of the history of colonization and its ongoing impacts, including practices and institutions that must be dismantled and reshaped to respect Indigenous people and Indigenous ways of knowing and being. It is also critical that we acknowledge the legacy of anti-Black racism and its relationship to HIV criminalization as we begin our symposium today. Together, we recommit in this space to repairing harms and working towards a more just future for all. So now we'll move to the first, to something I'm quite excited about. 10 years ago in 2012, we produced with the incomparable filmmaker Alison Duke, located here in Toronto, Positive Women Exposing Injustice. This documentary followed 4 incredible women living with HIV in Canada and the effects of HIV criminalization on their lives. This year, to mark the 10th anniversary, we decided to return to 2 of these women and see if anything had changed and what their message would be to policymakers about the impact of criminalization in Canada and beyond. We are honored that Jessica Whitbread and Lynn Thompson are both in attendance today to watch the premiere of Positive Women Revisited.
In 2012, we commissioned the film Positive Women Exposing Injustice, portraying women living with HIV in Canada and the effects of HIV criminalization on their lives.
I am from Pine Creek First Nations, from the tribe of Anishinaabe, which would be Ojibwe in English. I am an Aboriginal woman, two-spirited meaning a lesbian. My status as a positive woman has greatly affected my life. I believe for the first 8 years I didn't have a relationship. No one wanted to have a relationship with me, and it still happens today. They'll go, oh, okay. It just becomes a friendship then. It's no longer a relationship, and certainly not a sexual relationship. Once the breakup sometime has happened, I've had people go, well, I'm gonna charge you. It's just a retaliation thing, and very common, I think, with people living with HIV to have that happen to them, whether you're gay, lesbian, or straight, that often happens to us.
In 2001, met someone through friends. He was super cute, a bit older. We started to have like this hot love affair. We ended up breaking up, and I got a phone call about a couple months after, and it was him on the phone, and he was in distress. He said that another girl had tested positive. I was like, fuck. Well, the police framed it as in, you know, you're a victim. Like, I was put back into that victim role, like, he did this to you. Myself, I didn't charge him, but my name was brought up in court.
10 years later, in 2022, we went back to Lynn and Jessica to see how they've been and whether HIV criminalization remained an issue in their lives.
At that time, for me, the film was really connected to my experience with my ex-lover. I'm just thinking now, shortly after he committed suicide, which is, you know, I believe is a direct result from being part of the whole criminal justice system and being a white cis man who now had a criminal record for being on the sexual offenders list. So that has happened within that time, and it's really made me think even deeper about the impacts, in particular on mental health, quality of life, of criminalization for people living with HIV.
Bonjour, my name is Muskakit Kigwe. My government name is Lynn Thompson. I come from Pine Creek First Nations, Treaty 4. I now reside on the Coast Salish and ceded territory of the Musqueam, Tsleil-Waututh, and Squamish Nations, Miigwech. The film, I've actually been able to use it at the University of Saskatchewan, University of Alberta, University of Manitoba. In these settings, we will have people break down and cry because they didn't realize how marginalized we are and stigmatized we are by our Canadian government. I'm coming from a province where stigma is so prominent, and that's Saskatchewan. I just couldn't get the care and treatment I needed in Saskatchewan. And knowing that BC is the best for HIV in our country. So I was able to come here and now get on the meds, have a support system. And that support system is literally grassroots HIV positive people right now. We don't have a space for us to go share. COVID has been hard on us, and we still need to figure out how to take care of ourselves and have other people take care of us. We don't even have our elders around. We don't have our sweat lodges. So it's been real tough for HIV positive people in the last couple of years.
As someone who's been living with HIV since 2002, I actually still don't feel at all comfortable in a Canadian context not disclosing. The fear and the long-term impacts and the feelings of constantly being under surveillance are real.
With criminalization, it does come up once in a while, but not very often, because that's just a black cloud that hovers over us. It's something that I think we're well aware of it, but we tuck it way back in the back of our heads. It has affected my life. I did have a disgruntled landlord who actually tried to charge me for exposure. So that's a real reality, and that was only a couple of years ago.
In 2016, I got pregnant, and I'd been working on some global breastfeeding protocols, HIV criminalization cases, and in Canada, I knew that this was an area where the guidelines were clearly do not breastfeed. And it was formula feeding only. But I also knew that the WHO guidelines said different things for different places. In an African context, it was that women living with HIV should breastfeed for a to 2 years exclusively. So when I had the twins, I just remember being in that room and not breastfeeding, but wanting to so badly and feeling this real need and desire. I knew that there was other examples of children being taken away when a mother suggests or breastfeeds. There was one case where a woman living with HIV was charged, successfully charged.
My message to the government was, please protect us. We're still Canadians. We're a part of this great nation, and we need to relook at the laws and follow the scientific proof. We follow it with COVID. Why can't we not follow it with HIV/AIDS?
Don't you believe science? What age do you live in? No, but really, if there's a 0% chance risk if someone's undetectable, or there is a minimal risk if someone uses a condom, and there definitely shouldn't be any kind of, criminal law. You can be pissed off at someone. That is totally different. If you have an STI and you don't tell me, and then I get it, I can be like, screw you. Why didn't you tell me? I'm mad at you. That's quite different than, I want you to sit in a jail cell for 5, 10, 20 years. That is a totally different reality. The same as it's a totally different reality to say to a parent who may be breastfeeding her child with a less than 1% risk of transmission that, yes, your child is better off in a foster care system and detached from you. I think for the most part, people living with HIV are just trying to do the best that they possibly can with all of the information and the resources and the tools that they have. People living with HIV do not want to transmit HIV to other people, in particular their children. There's not a single HIV positive parent that's like, that wants it to happen.
Just because of the work that I do, I have to be extremely careful because I am reviving people. I have to do sometimes mouth-to-mouth resuscitation. I have to make sure that I am protecting the person that I am trying to save or bring back. A lot of my work will consist of literally looking for bodies, making sure people are breathing. Like yesterday, it was payday. We had people dropping along the sidewalk. They just drop, and you got to make sure they're okay. HIV has become a useful tool for me that I have changed into a positive lifestyle because I am able to help people that can't get what I can do. So I'm really proud of actually being HIV positive because I can work in other fields and really make an impact on the ground.
For people living with HIV in Canada, my fingers are tightly crossed that soon HIV criminalization won't be an issue, that we can frolic and be free and enjoy a robust sex life that we deserve, like every other person in Canada.
I want to say tremendous thanks to the women of Positive Women Revisited and the women of Positive Women, the original. I really hope we can move forward with our conversations today, understanding and centering the real world impacts criminalization has on people living with HIV in this country. These are just some of the stories. Now we're going to move to our first panel, Where Are We Now? Moderated by Richard Elliott, who, as many of you know, is the former executive director of the HIV Legal Network, a friend and colleague, now a lawyer and human rights consultant, and someone who's worked on HIV criminalization for many years. I'm going to turn the discussion over to Richard now with my thanks.
Thank you, Janet, and thanks everyone for joining here today. It's lovely to be amongst all of you talking about this issue. So in our first panel of the day today, we're going to set the scene and bring you up to date. I'm going to, first of all, kick things off with a very quick and dirty summary of where things stand with law and prosecutorial policy in Canada now. And then from our following panelists, we're going to be hearing an updated analysis of non-disclosure prosecutions that have occurred to date in Canada. We're going to be hearing about some research into the implications of sex offender registration, which is a consequence of HIV criminalization as it manifests in Canada. And we're going to be hearing an update about some of the recent work of the Canadian Coalition to Reform HIV Criminalization, including consultations in recent months to inform the coalition's advocacy to change the law in Canada and limit HIV criminalization. As you've heard already, if you could put your questions for the panelists in the Q&A box during the presentations, that would be great. And we'll come to these at the end after each of the presenters has had a chance to present. So let me give you then the quick legal lay of the land. Where do we stand currently? If you could advance to the next slide, please, Nick. So let me first of all just give you the very summary description of the legal framework in which criminalization is happening and in which our advocacy is happening. It's important to understand that we're talking about the application of federal law, specifically the criminal code, that on paper applies throughout the country. It's one law throughout the country. However, the enforcement of the criminal code actually falls to other jurisdictions largely. It is the provincial governments and therefore provincial attorneys general and their designated crown prosecutors who in each of the 10 provinces are responsible for prosecuting allegations of criminal code offenses. In the 3 territories in the north, it is federal prosecutors who are responsible for prosecuting criminal charges. And that's relevant for our advocacy about changing prosecutorial policy in Canada, because it means we have multiple different attorneys general and crown prosecution bodies to engage with. The law that those prosecutors are applying is not law that includes an HIV specific offense in the criminal code. Rather, the way that criminalization of people living with HIV is happening is through the judicial interpretation, so the interpretations by the courts of existing offenses in the criminal code that are of general application and that are being applied to specific circumstances in which HIV transmission, exposure, or non-disclosure is being alleged. And you see here on your screen the offenses in the criminal code that have been applied to date in Canada. And at the bottom of that list, highlighted in red, you see the offense of aggravated sexual assault. And the reason that that's highlighted is because it is by far the offense that has been used most often to prosecute allegations of HIV non-disclosure. Next slide, please. So very briefly, in summary form, how has that law been used to prosecute people living with HIV? What is the legal theory behind these prosecutions? Because this is what we need to engage with, amongst other things, in actually ending the harms of HIV criminalization. The basic argument that the courts have articulated and accepted is that when there is a duty to disclose your HIV positive status to a sexual partner, if you do not, then you have committed a fraud and you have gained your sexual partner's consent to that sexual activity through fraud, and therefore it's not legally valid. That turns that otherwise consensual sexual encounter into a sexual assault in the eyes of the law. So the question then becomes, when is there a duty to disclose one's HIV positive status? And the court has articulated that if there is a significant risk of serious bodily harm, then there is a duty to disclose. If there is not a significant risk of serious bodily harm, then there is no duty to disclose. That was what the Supreme Court of Canada first said in the late 90s. But 14 years later, the court revisited the question and dealt with specifically the issue of HIV and said that this significant risk of serious bodily harm means that there has to be a realistic possibility of HIV transmission. It's at that point that the duty to disclose arises. And if a person doesn't disclose, then they could be prosecuted for sexual assault. As worth noting, the prosecution also has to prove that the person who is complaining of the sexual assault would not have consented to sexual activity had they been aware of the person's HIV positive status. The reason that people are most often charged with aggravated sexual assault is that in the law, a sexual assault can be of differing degrees of severity, and the most serious version of sexual assault is an aggravated sexual assault, which the criminal code defines as, among other things, a sexual assault that endangers the life of the person who is alleging the assault. And so the courts have accepted that exposing someone to the risk of acquiring HIV is to endanger their lives. And so it's not only a sexual assault, but an aggravated sexual assault. Next slide, please. So this is the final slide, and it really speaks to one of the central questions in all of this, and that is, what does this phrase, a realistic possibility of transmission, mean? Because that's when the law imposes a duty to disclose to one's sexual partner. So we look to two things. We look to court decisions in various cases, and we look to prosecutorial policy in some jurisdictions to try to figure out where the lines have been drawn so far when it comes to defining a realistic possibility of transmission that triggers the duty to disclose and therefore a possible prosecution if you don't disclose. So what we can say with great certainty is that if someone has a low viral load, meaning under 1,500 copies per milliliter, and a condom is used for vaginal or likely anal sex, then according to the Supreme Court of Canada, there is no realistic possibility of transmission, and so therefore there is no crime for not disclosing one's status. So that's pretty clear. In recent years, it has increasingly been recognized by courts and in prosecutorial policy in some jurisdictions in Canada that if someone has an undetectable or a suppressed viral load, then that in and of itself is also sufficient to mean that there is no realistic possibility of transmission and therefore no duty in the law to disclose. So there is a recognition in Canadian law at this point, reasonably well established, of U equals U. Things are less settled when it comes to condom use. Is condom use alone enough so that you don't have to disclose to a sexual partner? And there are conflicting court rulings on this point in Canada. The most recent of them from the Ontario Court of Appeal, rejecting the argument from advocates that condoms are enough to mean that you do not need to disclose. It's a very disappointing decision, and therefore still very much a point for advocacy. There is some growing recognition in the prosecutorial policies that have been adopted in some jurisdictions that condom use is a factor that may lead to a Crown prosecutor deciding not to prosecute, but that's very fuzzy. It's not a clear, bright line test. And then finally, when it comes to the question of oral sex, we can say that it is not fully settled, but it is probably not that likely that someone will be prosecuted for not disclosing their HIV positive status in that case, because it is unlikely that there is going to be found to be a realistic possibility of transmitting HIV. So that's the current state of affairs in the law and prosecutorial policy, the legal backdrop, if you will, for the ongoing advocacy work that many on this call and in communities across the country are involved in. So let me stop there and invite our first panelist to join us. Colin Hastings is a postdoc at Concordia University in the Department of Sociology and Anthropology. And Colin, along with co-authors, including myself, Natisha Massaquoi, and Eric Mikolovsky, has done an updated analysis of the non-disclosure prosecutions to date in Canada, and he's going to share with us the highlights of that. Colin, welcome.
Thank you so much for the invitation to be here today. So as Richard said, I'm going to share some updated data on the key trends and patterns of HIV criminalization in Canada. And the full report that we produced is available online on the Legal Network website. I just want to start by saying that a report doesn't capture the broader effects of HIV criminalization that have been so powerfully articulated today by Jessica, Lynn, and Maria. But our hope is that this data on the current trends in prosecutions can contribute to our ongoing advocacy efforts to end the harms of HIV criminalization. So we don't have space today to delve too deeply into the full report, but there are some main findings that we want to highlight today. So on this first slide, we can see that there have been at least 206 people prosecuted in 224 different criminal cases in Canada between 1989 and 2020. And as this table shows, HIV criminalization cases have declined in recent years, and this likely has to do with the tremendously solid and sustained advocacy efforts that have been taking place across Canada. You'll see in the report that we trace some of the major milestones in advocacy to challenge how the criminal law is applied in instances of alleged HIV non-disclosure. On the next slide, we can see that the vast majority of cases since 1989 have taken place in 3 different provinces, Ontario, Quebec, and British Columbia. Ontario accounts for just over half of all cases, more than 3 times the number of cases in any other province. The large number of cases in Ontario reflects the fact that the province has the highest number and proportion of HIV diagnoses in Canada, and also has to do with the prosecutorial approach in the province towards cases of alleged HIV non-disclosure. In the next slide, we can see some of the ways that our report updates demographic data on HIV criminalization cases. Here, we see the proportional distribution of people who have been charged for HIV non-disclosure between 1989 and 2020. In previous reports on the demographic patterns in the criminalization of HIV non-disclosure, it's been noted that the criminal law appears to be increasingly used against people living with HIV from certain racialized populations. The updated data in the report confirms that this continues to be a major concern. In particular, concerns remain that Black men are disproportionately represented in HIV criminalization prosecutions. In 2017, our report also underlined that Indigenous women in Canada account for a significant proportion of women who face charges related to HIV non-disclosure, and this trend remains stable today. Given their disproportionate representation among people living with HIV in Canada, Indigenous women are another population heavily affected by the threat of potential prosecution in Canada. And qualitative research studies that have been carried out in Canada show that Indigenous women living with HIV experience over-surveillance by health officials, police, and the law as a form of colonial surveillance and racism. In addition to looking at demographic data, we also examined the outcomes of criminal prosecutions on alleged HIV non-disclosure. So on the next slide, we can see that a significant majority of cases have ended in conviction since 1989. 70% of all cases since 1989 have ended in conviction on at least one charge. And on the next slide, we can see that it's worth noting that since 1989, 64% of convictions have been the result of a guilty plea as opposed to a guilty verdict following a trial. We can advance to the next slide, please. This table shows that there are noticeable differences in the outcomes of cases when organized by race, particularly in comparison between Black defendants and white defendants, that raise major concerns about how racism affects the outcome of cases. For example, this table shows that racialized populations have lower rates of acquittal and having their charges dismissed, stayed, or withdrawn, and have a higher conviction rate. Meanwhile, white people have the highest rates of acquittal, charges dismissed, stayed, or withdrawn, and the lowest rates of conviction. The next slide, please. As we know, in Canada, people living with HIV can be prosecuted and often face very serious criminal charges, even in instances when HIV is not transmitted. Of the 224 criminal cases between 1989 and 2020, there have been 163 cases in which the HIV status of the complainant is known. There was no HIV transmission in 64% of the cases, and this trend seems to be intensifying. Since the previous report, there have been 16 cases in which the HIV status of the complainant is known. And in 75% of those cases, there was no HIV transmission, demonstrating that most HIV non-disclosure cases are about alleged or real exposure to the virus rather than transmission. On the next slide, we can see that the sentence is known for 124 of the 130 cases since 1989 that ended in a conviction. In only 6% of cases, just 8 of the 124, the defendant was given a conditional or suspended sentence and did not face prison time. An overwhelming majority, 94% of people convicted in HIV non-disclosure cases received prison sentences. And then the final slide. Disaggregating the data by race shows that Black people and Indigenous people are more likely to face prison sentences than white people. Of the 51 cases resulting in a conviction that involved a defendant who was Black, at least 73% resulted in prison sentences. Of the 16 cases resulting in a conviction that involved a defendant who's Indigenous, 75% resulted in prison sentences. In contrast, of the 79 cases that involved a white defendant, 57% of cases resulted in prison sentences. So again, we would invite you to review the full report that is on the Legal Network website. And in the meantime, to summarize some key points from our advocacy that emerge from this study. So first, we know that the criminal law continues to be used disproportionately against people living with HIV from racialized populations. Black men are disproportionately represented among those prosecuted for alleged HIV non-disclosure. Black and Indigenous people are convicted at a higher rate, acquitted at a lower rate, and are more likely to face prison sentences compared to white people who face similar charges. Second, the updated data underline concerns about how people living with HIV are charged and convicted, including in cases in which their sexual activities pose a negligible risk of HIV transmission or no risk of HIV transmission at all. This suggests that there's a need for continued advocacy to ensure that the criminal law is informed by the most recent science on HIV transmission. And finally, the Canadian criminal legal system's approach to HIV non-disclosure remains exceptionally punitive. There are stable trends that suggest that HIV non-disclosure cases have very high rates of conviction and that a large proportion of cases result in prison sentences. So overall, the report, which I can, Sandra has beat me to it, put a link to in the chat, highlights the urgent need for the criminal legal system to be better guided by science and human rights principles in responding to HIV, and for immediate government action to end the harms of HIV criminalization in Canada.
Thank you, Colin, for doing an excellent job in summarizing a very dense and rich report that I hope will be a very useful tool for our ongoing advocacy to limit HIV criminalization. And I would encourage people indeed to read the full report. Obviously, one of the important things that has been highlighted there is that HIV criminalization is also a racial justice issue as well. Now, Colin mentioned at the end there the exceptionally punitive nature of HIV criminalization in Canada. One of those dimensions is that when someone is convicted of sexual assault, the current state of the law is that they are mandatorily designated a sex offender and then subject to additional forms of control and surveillance and punishment. And our next panelist, Liam Michaud, is going to speak to recent work that he's been doing on this issue. Liam is a PhD student in socio-legal studies at York University. Welcome, Liam.
Hi, everyone. Thanks for having me today. Thanks for that, Richard, and great to be here with you all. So this research was a collaboration between the following people at the Legal Network, at HALCO, and the ICCJ at Carleton University. And it was an attempt, more or less, to gather in one place the collective harms experienced by people criminalized for alleged HIV non-disclosure, and specifically of their designation as a sex offender under the Sex Offender Information and Registration Act, or SOIRA. So this report builds on the research, the initial research of Alex McClelland with people criminalized for alleged HIV non-disclosure, the majority of whom were subsequently registered as sex offenders. It's important to note that in addition to being significantly overrepresented in HIV crim cases, more generally, that Black men and Indigenous women were significantly represented among those subject to the Sex Offender registration requirements. So this report basically brought those experiences of criminalization more generally into dialogue with the specific legal provisions, which are the sources of those harms. Most significantly SOIRA, but there are others which I'll comment on. So the research was also developed to support the Nodolovu case before the Supreme Court, arguing Section 7 charter violations, which you can read more about in the report, which we can share in the chat. Next slide. So thanks, Richard, for the context you provided earlier. I'll share a couple of additional pieces to map out the legal landscape and how these interact with other dimensions of criminalization before providing an overview of the harms as experienced and recounted by people living with HIV subject to sex offender registration. So just to be clear, designation as a sex offender in these cases is a function of HIV criminalization, the criminalization of HIV non-disclosure more broadly. So as mentioned, the most common charge used against people is aggravated sexual assault, which then triggers compulsory registration. So SOIRA, which is the federal legislation, provides the basis for the registry, which is the NSOR, the National Sex Offender Registry, which is managed by the RCMP. The stated purpose of the legislation is supposedly not punitive, but rather about aiding in police investigations, and the rehabilitation and reintegration are among the stated principles of the legislation as well. Next slide, please. So individuals mandated to register with the NSOR are required to provide extensive identifying information, including the following. This is not exhaustive though. In 2011, the criminal code was amended. This was Bill S2, which resulted in a number of offenses automatically resulting in sex offender designation and mandatory registration, among them aggravated sexual assault. Next slide. So as a result of these amendments, all people living with HIV convicted of aggravated sexual assault for non-disclosure became subject to the mandatory sex offender registration. This was in stark contrast to the legal situation before the 2011 amendment. So in effect, the amendments removed Crown and judicial discretion. Failure to comply with registration requirements can result in a fine of $10,000 or up to 2 years imprisonment. Individuals can remain in an active status on the list for 10 years, 20 years, or for their entire lifetime. Next slide. So SOIRA, while SOIRA doesn't have specific provisions which allow for community notification, when I say community notification, I'm talking about where information regarding those convicted of sex offenses is made available to the general public. Nonetheless, information regarding sex offender designation and status can become publicly known, and it does become publicly available through news media reporting. So news media reporting on conviction and corresponding registration expose people to widespread housing and employment discrimination. One person recounted being told, "We don't rent to rapists." There's also evidence that this information can be leaked by correctional officers, as well as how sex offender designation can be deduced or assumed based on charges following the 2011 amendments. Sex offender designation also triggers specific responses by correctional authorities, which result in their own harms, including deeply invasive and traumatizing sex offender treatment programs. And again, this is elaborated in more depth in the report. So there are a number of harms which stem from the public disclosure and circulation of this information, but also specific harms which stem from SOIRA and the mandatory registration specifically. So I'll comment on those briefly now. We should note that many of the harms described here echo research on sex offender registration more generally, which point to a lack of evidence that they reduce recidivism or reduce the prevalence of sexual crimes, and that they undermine reintegration efforts. The first of these harms described by people was family estrangement and internalized stigma. Sex offender designation places significant strains on relationships. It undermines family reunification following release from custody. People spoke about being regarded as dirty by family members. Sex offender registration also significantly undermines people's reintegration efforts following release, taking up previous volunteer engagements, pursuing personal goals, pursuing career paths. Importantly, these experiences stand in stark contrast with SOIRA's stated principle of public interest in the, quote, rehabilitation and reintegration of sex offenders. Next slide, please. I'm on the registry that is for rapists and pedophiles. I really don't feel like I belong there. I am on there because of HIV. I have to let people know when I'm working or when I'm volunteering. They need to keep tabs on me. Another significant source of harm is the psychological distress arising from potential lifetime of police surveillance and excessively burdensome registration requirements. People spoke to the fear and anxiety related to the threat of rearrest in the event of an unintended breach of conditions long after they had finished serving their sentence. Next slide. To label someone a sex offender, you know that's for life. The sentence is over, the 3 years, but this is until you die. I think it's really unfair, you know, like it's hard to travel. It's really hard that someone has to carry that for the rest of their life. Several individuals interviewed were subject to random checks by local law enforcement to ensure compliance with SOIRA requirements. So it's important to note that there are no provisions in SOIRA for random checks, but this kind of reflects the arbitrary nature of enforcement activities and shows how the federal legislation interplays with other factors, including the discretionary practices of law enforcement. Annual registration brought up painful and traumatic memories of incarceration, including HIV-related stigma and violence experienced at the hands of guards. People spoke to the profound stress and prolonged periods of suicidal ideation experienced due to a combination of these factors. So I'll just finish up. So what are the takeaway messages here? Next slide, please. The stated purposes and principles of SOIRA do not include the punishment of those on the NSOR, yet people living with HIV required to register as sex offenders clearly experience SOIRA as punitive. 2, that people's experiences of the broader sex offender regime in Canada show how the federal legislation can interact with and set into motion a series of cascading or related harms, including media disclosure of sex offender status, which can then lead to vigilante harassment and discrimination. 3, that the harms produced by sex offender registration interact significantly with the systemic racism embedded in the criminal legal system at multiple levels, including risk assessments, release conditions, dangerous offender designation, and that future research is needed to disentangle the interplay of these factors. Finally, what the legal landscape and people's experience underscore here, I think, is that meaningful efforts to reform HIV criminalization and unjust sex offender registration need to engage with the multiple sources of harm experienced by those subject to them. So I'll end there. Thank you.
Great. Thank you so much, Liam, for that incredible research. And again, another piece of work and documentation that I think is going to be really super helpful in the ongoing advocacy to end the harms of HIV criminalization. So turning then to what is to be done about this, I'm delighted to invite Leah Pelletier-Marcotte and India and Anamantadu from the HIV Legal Network and Leah from COCSIDA to share with us some updates about what has been happening with the Canadian Coalition to Reform HIV Criminalization and some current work on actually changing the criminal code, including to deal with the harms that have been identified in the previous presentations. Leah in India, over to you.
Thanks, Richard, and I'm very happy to be here and be speaking on behalf of my fellow coalition members. So I think we have a little PowerPoint to show you, but just as we begin as a way of background, the Canadian Coalition to Reform HIV Criminalization was formed in 2016. The goal was really to organize around the common objective to progressively reform the overly broad criminal and public health laws that criminalize and regulate people living with HIV in Canada, especially in relation to HIV non-disclosure, exposure, and transmission. Members of the coalition include people living with HIV, including survivors of HIV criminalization, community organizations, lawyers, and researchers from across the country. Next slide, please. In 2017, the coalition released its community consensus statement, which calls for criminal prosecutions to be limited to cases of actual intentional transmission of HIV. The statement was developed through discussions and community consultations, including an online survey. It took about a year to develop. The statement called for many things, including for legislative reform, meaning to change the Canadian Criminal Code to limit HIV criminalization. That included to remove HIV non-disclosure from the reach of sexual assault laws and ensure that other provisions in the criminal code were not used to further stigmatize people living with HIV. The statement has been endorsed by over 170 organizations so far. Next slide, please. So since that call for action, the coalition has engaged with all levels of government on the issue of HIV criminalization, and there have been a number of developments that signal a certain openness to the idea to proceed with legislative reform. In December 2016, the Attorney General of Canada, for instance, recognized the need to address the over-criminalization of people living with HIV in Canada. And a year later, a Justice Canada report made recommendations to address the issue, including prosecutorial guidelines and changes to the criminal code. In 2017, a federal directive was issued. This directive effectively limited HIV criminalization in the 3 territories. And finally, in 2019, the House Standing Committee on Justice and Human Rights released a report on HIV criminalization that effectively called for changes to the criminal code. So as the government's commitment and willingness to address the issue through legal reform became all the more clear, the coalition had to hash out in more details its ask for criminal code reform. And I'll let India guide us through that very specific process. To you, India.
Thank you, Leah. So in order to translate those big calls to action into concrete reform proposals, in the fall of 2021, we launched a second Canada-wide community consultation. Now, the goal of this second consultation was twofold. The first was to establish whether the community still had an appetite for reform 4 years after the release of the 2017 statement. And 2, if so, to solicit their feedback on the proposed reforms. That consultation took place primarily as an online survey and through several live consultation workshops, including sessions that were organized by and for the Indigenous community, the African, Caribbean, and Black community, the MSM community, and a session for cis and trans women. Out of this second consultation, our hope is to produce a second community consensus statement that outlines our preferred options for reform and serves as the basis for advocacy with the federal government going forward. Next slide. So I'll use my last couple minutes to just outline the options that we put forward to the community in this latest consultation. You'll see here that the first 2 options are substantive reform options, and both would achieve the goal of limiting prosecutions to actual and intentional transmission and remove these cases from the reach of sexual assault. But as you'll recall from Richard's introduction, other non-sexual offenses have been used in the past to prosecute people living with HIV. So if our reforms were only to restrict prosecutions in the case of sexual assault offenses, we would expect a sort of whack-a-mole effect, which is to say that prosecutions would start popping up under these other non-sexual offenses. So in order to restrict the use of the criminal law in a wholesale manner, we've developed 2 options, which are packaged differently, but ultimately achieve the same end result. In the first option, the interpretive provision, this would be a provision that's added to the criminal code, which would shape the interpretation of all existing offenses in the code so that they could be only used in cases of actual and intentional transmission. At the same time, this interpretive provision would explicitly prevent the use of sexual offenses. What this means is that there could be no crime under any offense in the criminal code unless the prosecution could prove actual and intentional transmission. The second option is an HIV-specific offense. And this offense is an offense that could only be used in cases of actual and intentional transmission and would also prevent the use of any other offenses in the criminal code. What this means is that people living with HIV could only be convicted under this one new offense and no others, and only in the narrow circumstance of actual intentional transmission. The third option you'll see was the status quo, which was to not advocate for any changes to the criminal code and accept the law as it is. And this was included as a recognition of the risks associated with law reform. As a community, we can propose our preferred reform, but ultimately, once in the hands of the government, the final product is out of our control. And although we are still interpreting the results, it is clear that despite these risks, the community agrees that the status quo is unacceptable and that it is time we push for law reform. So I want to thank you all for your attention and listening. And most importantly, I want to thank the coalition and especially the members and people who have experienced criminalization for being a constant source of inspiration and pushing us towards justice. Thank you for all you do for this community.
Thank you, India and Leah, for that update. There's lots more, obviously, that could be said about each of these presentations, and there are a number of good questions that have already come up in the Q&A box. I would encourage people to post additional questions there as they occur to you, and we'll keep an eye on that and try to steer them to the relevant panelists. We have about 20 minutes remaining, I believe, for the Q&A in this session. And I'm going to take the prerogative of being the moderator to answer one of the questions that has come up in the Q&A and then toss one of the other ones to our panelists. There was a question about the obligations of cisgender women living with HIV who are having sex with other women, about disclosure. And two things to just note in response to that question that has come in. The first is that it would not seem likely that in most circumstances there is going to be conduct that poses a realistic possibility of HIV transmission. And so the possibility for prosecution is probably quite limited. And indeed, there have been no cases that we're aware of to date of women living with HIV prosecuted for sexual activity with female partners. So that's something to note. The women that have been prosecuted have all been prosecuted in relation to sexual encounters with male partners. One of the other questions that has come up is whether other sexually transmitted infections have been prosecuted. And perhaps I could invite Leah or India to speak to that question. And I would invite all of our panelists to turn their cameras back on and join us back on stage for this Q&A portion. Welcome back. So Leah or India?
Maybe I'll try my best, India, and if I forget anything, you can come in, or if I say something crazy, you can come in. Thanks, Richard, for this. So there have been attempts to use the current state of the law for other STIs, but we have to remember that the Maybe-or test that you've so masterfully explained applies to HIV more specifically, but the state of the law under and the tests laid out under Courier would be open to be used under other STIs as well. So the door is not closed for the criminal prosecutions for non-disclosure and exposure to other STIs as well. And if I can come in and talk about more specifically about what's happening in Quebec. In Quebec, we've seen cases for other STIs being treated very differently as civil cases and not as criminal cases. So that might be an option. And we see the clear difference between how then HIV is treated compared to other types of STIs, even herpes, which is another incurable infection. So that's my 2 cents on that.
Yes, I would add just to say that there have been a handful of non-HIV STI criminal cases. And like I said, it does not compare to the number of prosecutions for HIV non-disclosure, as we saw from Colin's presentation.
Thanks, India. In fact, I think there have been 8 prosecutions that we're aware of involving allegations related to other sexually transmitted infections compared to the 224 prosecutions related to HIV, as Colin had outlined at the beginning. One of the other questions that has come up is the question of expunging past convictions under sexual assault charges for people if there has been a recognition, at least in the recommendations of the House of Commons Standing Committee on Justice, that we should not be using sexual assault charges to prosecute people living with HIV. And if advocates are successful in ultimately achieving the end of sexual assault charges, what do we do then about people who have been previously convicted under the criminal code of this offense? I wonder if either, again, Leah or India want to speak to what some of the discussion is that's been happening amongst advocates about this strand of advocacy. And Liam, of course, if you'd want to come in as well, given that it touches on your research, please feel free.
Leah, do you want to go ahead?
Yes, I just want to say that on the advocacy side of things, that's definitely now on the top of our list. Advocating for criminal code or legislative reform will come with, we want to prevent this blind spot from happening. We want to make sure that we also do address the issue of people who have been convicted, and that's really important as well for survivors of HIV criminalization. So it will definitely be part of our advocacy moving forward.
Great. On this point about the consequences of a conviction for sexual assault, including mandatory registration as a sex offender, there's a good question and comment from our colleague Alison Symington in the Q&A box about the irony of women who have been charged and prosecuted finding themselves on the sex offender registry with all of the harm that flows from that. And yet when you compare this to the limits of the use of sexual assault law in prosecuting cases of sexual violence generally, it leaves women unprotected. I wonder if any of our panelists want to comment on this, including maybe Liam, given your research on this topic.
Yeah, thank you for that really important question. So this is absolutely, thanks for highlighting that. This is something that I think Alex can speak to in more depth, given his initial research, and I think he responded in the chat, in the Q&A there, if you want to take a peek. But I mean, this was definitely something highlighted among those interviewed. I mean, there are very kind of horrifying gendered dimensions to this. And I think that's absolutely something that needs to be centered in advocacy. I think, you know, that was something that also came up in terms of the kind of differential or particularly gendered impacts of media reporting and of sex offender treatment as well. So those are things that I think need to be kind of explored in more depth, perhaps in kind of future advocacy and next phases of research. The other thing that I just kind of encourage us to keep our eye on or keep in mind, which wasn't covered in much depth in the report, is, you know, the issue of community notification. Right now, as I mentioned, there isn't provisions in SOIRA for community notification, but it remains to be seen. And though those interviewed by Alex in his initial research weren't subject to community notification, it remains to be seen like how vulnerable people prosecuted for HIV non-disclosure remain to this. And there have been kind of ongoing shifts legally and pressures, you know, proposed legislation, et cetera, a recent measure in Ontario around specific community notification requirements too. So, and that as well will likely have, you know, gendered implications, kind of differential specific impacts for women living with HIV as well. So yeah, I'll leave it there for now.
Great, thank you, Liam. Just to briefly answer one of the questions that was posed in the Q&A, there was a question from Réjean about which sections of the criminal code criminalize HIV. And just to note that, oh, I see that question has, I think, just disappeared from the screen. Just to note, again, from the opening presentation, there are no specific offenses in the criminal code about HIV. It's the use of existing offenses, including sexual assault offenses in particular, that have been used to prosecute people living with HIV for alleged non-disclosure. And this is why the different ways of approaching criminal code reform to limit HIV criminalization need to deal with the question of sexual assault law specifically. And that actually takes us to a couple of other questions that have been raised in the Q&A box. And there's a good question here about the two different options that India laid out in summary form. Would either or both of these options, this again comes from Alison, would either or both of these options change Canada's sexual assault provisions beyond excluding HIV non-disclosure prosecutions? Are there risks that the proposed reforms could weaken or strengthen the usefulness of the provisions in cases of, quote, real sexual violence? So I would invite maybe India or Leah to speak to that, but any of our panelists as well.
Sure, I can get us started and then Leah can probably pick up. I think, yeah, that's a great question, Alison. The proposals that the CCRHC are working on are related to HIV-related cases, not just HIV non-disclosure cases. So it would limit those prosecutions as well when we're talking about sexual assault offenses. And yes, to your point about, is this going to weaken in cases of sexual violence? I mean, I think, you know, in cases where it's related to HIV non-disclosure, if in the future there's also facts of sexual violence that are implicated, regardless of that person's HIV status, they will continue to be prosecuted under sexual assault provisions. What we're trying to get at is to limit prosecutions that are just because of somebody's HIV status and don't implicate facts otherwise related to sexual violence and are solely because of HIV non-disclosure. That's our goal as a coalition. Leah, do you want to add?
Yeah, and if I may add, one of the things that is more damageable to the current dispositions around sexual assault, actually, it's the actual state of the law and the way it's been interpreted that actually weakens the substance of these dispositions. And I think some feminist groups do agree that actually seeing the rates of cases being prosecuted, HIV non-disclosure cases being prosecuted under sexual assault laws, and seeing the high conviction rates for HIV non-disclosure cases compared to the very low conviction cases for quote unquote real sexual assault cases, it's actually this state of the law and the way we are using sexual assault laws currently that weakens the substance of sexual assault. So the options proposed would not affect the substance and would even reinforce their weight.
Thank you both. Since we're talking about different approaches to criminal code reform to deal with the harms of HIV criminalization, let me go to the question that Daphne has posed in the Q&A box. She wonders whether participants in the coalition's consultation were presented with the option of full decriminalization, and if not, how to justify that omission. So again, this sounds like it's probably a question for Leah and or India regarding the consultation.
Thanks, Daphne. Happy to start us off. So our intention with the second round of consultation was to build off the 2017 consensus statement. And in that statement, we agreed that prosecution should be limited to cases of actual and intentional transmission. So we were not starting off on a foundation of full community support for decriminalization. The last consultation was just to limit prosecutions to actual and intentional transmission. And so that is where we took our lead from. And, you know, just to add that we are a coalition of diverse voices. And it's true that not everybody in the coalition has one unified position on whether we should be rooting for full decriminalization or not. And so as a coalition, limiting cases to actual and intentional transmission is a lowest common denominator that we can all stand behind and root for. Leah?
I think you put it very nicely and wonderfully.
Great, thank you both. I think it may also be worth noting that that is also an international consensus amongst advocates working on HIV criminalization, and consistent with recommendations from various international bodies as well about limiting HIV criminalization. There's a question here from Greg about whether there are currently any mechanisms for forms of restorative justice or alternative dispute resolution before criminal prosecution under current HIV non-disclosure laws. Anyone want to weigh in on that?
I think this is something that was raised during the consultations. Evaluating the possibility of moving towards restorative justice principles. India, since I was not party to this consultation, would you like to come in with a little more detail as to what was discussed and proposed?
Yes, so this came up in our discussion held with CAN, and I think from that, we don't know of any restorative justice approaches that are currently in use for HIV criminalization, but it is something that we are going to take a look at as a community, and those discussions will be ongoing in the spring.
Thank you. And going to one of the other questions here, one of our participants has noted the history of Black and other racialized men facing false sexual assault allegations from white women, and looking for any thoughts from the panelists about how reforms would protect people who are most vulnerable to criminalization. Our participant would also be happy to hear people's thoughts about how our HIV criminalization advocacy can either help or hinder abolitionist initiatives to challenge criminalization overall. Who would like to weigh in on that? Any of our panelists?
I can comment briefly and maybe pass it off. So I thank you for that. I think it's a critical point. I think this is also why, as we were trying to kind of disentangle all of these different sources of harm, right, which was what led us to, not only narrowly looking at SOIRA, while SOIRA creates specific harms, right? We know that even if provisions in SOIRA were no longer there, that would not dismantle the systemic racism faced by, people facing criminalization more generally. And so, I think that in addition to kind of keeping our eye on things like community notification, we know that sex offender designation also interacts with there more research and more understanding needs to be, we need to explore how that interacts with dangerous offender designation, long-term offender designation, which are other designations which we know racial injustice and systemic racism is very much at play, the risk assessments that are used in making those kinds of determinations, right? So yeah, I'll leave it there. I don't have specific thoughts right now around reform and abolition, but I'll pass it off to others.
I'll just quickly add that I think a number of the panelists and questions have articulated really clearly so far today the importance of understanding HIV criminalization as a racial justice issue, as a gender justice issue, and to not sort of think about these in silos, that if HIV criminalization were to be completely decriminalized tomorrow, that would not address the broader longstanding structural forms of discrimination and racism that exist. So important to be understanding this as part of and connected to broader struggles that are ongoing.
Thanks both. And I think the questions and the discussion, of course, highlight the inherent tension as well in the exercise that we're engaged in here, which is trying to limit the harms of HIV criminalization, knowing that we have this exceptionally punitive and overly broad use of the criminal law for a few decades now. What can we do through changes to the criminal code that would limit those harms? And as India alluded to in an earlier answer, one of the options to consider is doing nothing, because we know there are risks involved when we start to push for changes to the criminal code. And while we might want to see certain limits created by Parliament on the use of the criminal law, that doesn't mean that we're going to get enough support in Parliament to do that. So we also have to be not only ambitious, but pragmatic too, in what we think we can get changed by Parliament to limit the many cases of prosecution that are going ahead, that are unscientific, that are unjust, that are doing a great deal of harm. There are a few other questions here. Some of them aren't specific to the matter of HIV criminalization, although they're good questions, which is why I've left them perhaps to the side for the moment, given the focus of today's discussion. And I see that we're also actually coming up on the end of this Q&A portion, if my countdown clock is correct. So I'm going to leave it there for now. But thank you all for your participation. And I think it's probably fair to anticipate that in the next segment, some of the questions and the issues that they've surfaced are actually going to resurface in the discussion that we're going to have in the next panel, which is about minimizing harm. And in this instance, not through law reform processes, which has been a big focus of this discussion, but through litigation as a strategy, as another part of the ongoing advocacy effort. And that panel is going to be moderated by Shakir Rahim. So I am going to turn it over to him, and thank you all, and thank you to our panelists.
Hi, everyone. So it's a pleasure to be moderating this panel today. My name is Shakir Rahim, and I'm a lawyer practicing in criminal defense and human rights law at Kastner-Lamb here in Toronto. I'm also a board member of the Legal Network in HALCO and a member of the Coalition to Reform HIV Criminalization. So before I introduce our panelists today, and we have two panelists on this panel, I'm going to provide you with some background on a case before the Supreme Court called R.V. Hutchinson, which is going to situate our panelists' remarks today. So Hutchinson was a case in 2014 before the Supreme Court of Canada that concerned a victim of sexual assault who had agreed to have sex with an accused person if they used a condom. And the accused person, without the complainant's knowledge, and we use the term complainant and victim interchangeably here, poked holes in the condom and the complainant became pregnant. So how does this factual situation relate to the issue of HIV non-disclosure? Well, the Supreme Court held that the reason that this was sexual assault was the same framework that applies to HIV non-disclosure that Richard discussed earlier, that fraud invalidated consent to the sexual act. The court also examined and rejected another framework, and I'm going to discuss the framework they rejected first because it's going to be relevant for our panelists' remarks today. So in Canadian law, there is a requirement that both partners must consent to the sexual activity in question. So both parties have to agree to the same sexual act in order for there to be valid consent. So the Supreme Court looked at the question of, by poking holes in the condom, did the accused person in the Hutchinson case engage in a different act than the sexual activity that both parties agreed upon? And if they did, that would be sexual assault. So one party says, look, I want to have sex, but I want to use a condom. Another party says, okay, but one person pokes holes in a condom. The question is, now do we have a different sexual act than the one both parties agreed to? And the court held that it wasn't the case that by poking holes in the condom, a different sexual activity occurred. And in the court's view, the use of birth control, like a condom, does not form part of the sexual activity in question that both parties agreed to. And the court compared this to HIV status. So they held, or they noted, that the HIV status of a partner does not form part of the sexual activity in question either. So the next thing the court examined in Hutchinson is whether the accused person, the person who poked those holes in a condom, committed fraud that invalidated consent. And remember, this is the same framework that applies to HIV non-disclosure cases. And there are two parts to fraud under this framework, two elements of the legal test. The first is there has to be a dishonest act. So somebody lies or omits important information from their partner. And the second is there has to be a deprivation or a risk of deprivation. And in the case of HIV non-disclosure, that deprivation is a significant risk of bodily harm, serious bodily harm. So what the Supreme Court found in Hutchinson is that by damaging the condom, the accused person committed a dishonest act and deprived the complainant of something as serious as a risk of significant bodily harm that occurs in the HIV context. And that deprivation was the complainant's choice to become pregnant or to increase the risk that she would become pregnant. And so the court found that there was sexual assault committed for that reason. So the primary takeaway from this, the relevance to the discussion on HIV non-disclosure, is that the court applied the same framework about fraud invalidating consent to this question around whether a condom was correctly used in terms of what both parties had consented to. So you see an importation of the law from the HIV non-disclosure context. And then I'm just going to briefly discuss a more recent case from 2022 called Kirkpatrick that was also about condom use and consent that the panelists are going to speak about. And this case has been argued at the Supreme Court, and the decision is forthcoming. And in Kirkpatrick, the complainant agreed to have sex with the accused if they used a condom. But the accused person, without the complainant's knowledge or consent, did not use a condom. Now, there is a difference from the Hutchinson case that I talked about earlier, and that is, in that case, the accused person used the condom, but damaged it without the complainant's knowledge or consent. Here, differently, the condom was not used at all, even though the complainant thought that it was. Now, unlike the Hutchinson case I discussed earlier, a lower court, the Court of Appeal for British Columbia, found that this was sexual assault because the sexual activity that occurred was different than the one that the two parties agreed upon. That was sexual intercourse without a condom is what the accused person did, which was not what both people had agreed to, which was sexual intercourse with a condom. So the important distinction to keep in mind for our panelists' remarks is that in Kirkpatrick, the court did not apply the fraud invalidating consent framework that is applied in HIV non-disclosure cases. And so our speakers, who I'm now going to introduce briefly, are going to talk a little bit more about why this area of law around condom use and consent is relevant to the HIV non-disclosure jurisprudence. So let me briefly introduce both of our panelists. The first is Isabel Grant. She's a professor at the Allard School of Law at UBC, specializing in criminal law, who has published extensively on the problems with Canada's approach to the criminalization of HIV non-disclosure and on sexual assault law more generally. She has worked with interveners in numerous cases at the Supreme Court of Canada on sexual assault, disability, and HIV non-disclosure. Our second panelist, Khalid Jan Mohammed, is the Director of Legal Clinic Programs at the Lincoln Alexander School of Law. He's previously Director of Litigation Services at the HIV/AIDS Legal Clinic Ontario, during which time he acted as counsel jointly for HALCO and the Legal Network in several cases. He has a particular expertise in human rights, privacy, public health, and charter-related cases. So I'll start off with a question for you, Khalid, which is, why does Kirkpatrick matter to people living with HIV? Why are we talking about condom refusal when this case does not relate to HIV?
Thanks, Shaker, and thanks to the Legal Network for having me here today. So before I answer that question directly, I'll just start by saying that my own personal view, and I believe the Legal Network and HALCO share this view to some extent, is that we should largely do away with carceral state responses to justice issues. In plain words, there are better ways to deal with problems than putting people into prisons. But the reality of our legal system today, as we've already heard about in the previous panel, is that people living with HIV face the risk of criminal charges if they don't disclose their HIV status before sex in some circumstances. And there's also the reality that came up in the Q&A for the last panel, that women who come forward after facing sexual assault are often disbelieved, discredited, and mistreated when they seek recourse. And I say all this because what the Supreme Court is really going to decide in this Kirkpatrick case is when someone could face criminal charges and conviction for certain sexual conduct in ways that relate to sexual assault law and potentially the law that applies to HIV non-disclosure. And so we have to grapple with these two difficult realities as part of thinking through this case. And to get back to the question, why does the case matter for people living with HIV when it's about condom refusal or removal? You hear both of those terms used in the context of this case. It's because it really comes down to trying to minimize the risk of the criminalization of HIV non-disclosure being expanded in any way. And let me explain why that is and why that happens in this case. The starting point is that people living with HIV have faced over-criminalization in Canada. And we know this has been recognized by the federal government, has been commented on by many academics and thinkers, including my co-panelist, Professor Isabel Grant. And because of that over-criminalization, people living with HIV and those who advocate on their behalf, like HALCO and the HIV Legal Network, are always concerned anytime a court, especially the Supreme Court, being the highest court in the country, has to make decisions about the law that could potentially expand criminalization of HIV non-disclosure. And Kirkpatrick is one of those types of cases where that risk is present. Ideally, as we've heard, we'd like to see HIV non-disclosure removed from sexual assault law. And some would also say removed from criminal law altogether, as some of the questions from the previous panel alluded to. But until that happens, getting involved in these kinds of cases is a form of minimizing the harm done by the criminal law. So why does Kirkpatrick relate to HIV non-disclosure? As Shaker mentioned in the introduction, leading up to the Kirkpatrick case, the law that applied to HIV non-disclosure and the law that applied to condom removal without consent in some circumstances was the same law, the sexual fraud analysis. So that meant that if the Supreme Court in Kirkpatrick broadens the law that applies to condom removal in any way, there's a chance that this could carry over to the HIV non-disclosure context and broaden the fraud analysis that applies in that circumstance. And so the concern was that this could result in people living with HIV facing more criminal charges. But there were ways for the court to avoid this problem in the Kirkpatrick case. The first way would be that if they decide to broaden the law that applies to condom removal, this fraud analysis, as the law currently stands, they could specifically say that any changes they make to that law apply only to condom removal and not to HIV non-disclosure, so that there is no confusion, no broadening of the law as it applies to HIV. The second option would be to place condom removal in a different area of sexual assault law, which would mean that HIV non-disclosure and condom removal would be considered under different laws. And the risk of the law being carried over from condom removal cases to HIV non-disclosure would be minimized in that second option. So the reason this case is important then, and the reason that HALCO and the HIV Legal Network participated in the case, was to make clear to the Supreme Court that they had these options to avoid expanding criminalization of HIV non-disclosure, and try to convince the court that the best of these two options, in our view, would be to use that different law for condom removal, to move it to a different area of sexual assault law, which we can get into more detail later.
Thank you, Khalid, for those remarks. And I'll now turn it over to a question for Professor Grant. And that is, what does Kirkpatrick mean for sexual assault outside of HIV? And in particular, why is there a tension, or is there a tension, between those two interests? And what are the other implications that exist for sexual assault law?
Thanks very much, and it's a real pleasure to have an opportunity to speak here today. I've been working for years on the problem of the overcriminalization of people with HIV, and more recently, I've kind of tried to look at the other side of the coin and say, okay, we know it's bad for people with HIV to have non-disclosure treated as a form of sexual assault. What does it do for the rest of sexual assault law outside of the HIV context? And that's what I've been asked to speak about today. Very simply, I think the courts at some level realized that they went too far on HIV non-disclosure, and they're kind of frantically trying to backtrack a bit to prevent even broader criminalization. But those concerns that we see in the HIV context do not apply in the sexual assault context outside of HIV. The statistics we saw this morning that Colin set out about the rates of overcriminalization and the incredibly high conviction rates, those are in stark contrast to what we see in sexual assault prosecutions. Sexual assault is under-prosecuted and under-enforced. So we have kind of policy tensions pulling us towards reducing criminalization for people with HIV, but different policy considerations pushing us in another direction for sexual assault generally. And while I agree with Khalid that we should be trying to reduce our reliance on criminal law, I think we need to be really cautious about starting with sexual assault when we do that, which is a crime that predominantly harms women. And if you look at the numbers, you'll see it predominantly harms Indigenous and disabled women and other women in other marginalized groups as well. So why is condom refusal so important? I think it's really important to draw the line, and people have done this to some extent already, between condom deception, which is what was described happened in Hutchinson, a man who tricked his partner into thinking he was using a condom, and condom refusal, which is what we see in Kirkpatrick, someone who just disregarded the complainant's wishes to only have sex with a condom. Hutchinson dealt only with condom deception, and they said that condom deception is like HIV deception. You're denying vital information to your partner, and that denial, lack of information, puts them at risk. And so in Hutchinson, the court was very much preoccupied with not expanding HIV, but in the process, what it did was distort sexual assault law in other contexts. And that's what I hope to show you a bit more today. The central question that's raised by both condom refusal and condom deception is, does a person have a right to decide how they will be touched sexually? The Supreme Court of Canada, in a case called Ewan Chuck, said, yes, it's fundamental to autonomy that you have a right to decide how a person touches you sexually. So presumably that means with a condom or without, should be totally within the right of the potential complainant to make that decision. Hutchinson takes away from that right, and that's why it's so problematic for sexual assault generally. Kirkpatrick looked not just at condom deception, but at condom refusal. And what Kirkpatrick tried to do was say condom deception is different than condom refusal. With condom deception, we'll go with that fraud framework that the court set out in Currier and more recently in Hutchinson. But with condom refusal, the court said that's really important that we treat condom refusal as directly going to consent without having to get to fraud. And why does it matter whether we get to fraud? It matters because fraud is only established where there is a significant risk of serious bodily harm. When you look at the cases that involve condom deception and condom refusal across the country, you will see that the difference between deception and refusal is not a very clear line. It may depend, for example, on whether the person was standing behind the complainant when he took off the condom, so she didn't see it. In that case, it's deceptive. If he's standing in front of her when he takes off the condom and she sees him take it off, then it becomes condom refusal. And the position I take in terms of sexual assault law is that this distinction is flatly ridiculous. That the harm that you're doing, which is denying the complainant the opportunity to choose what kind of sex she wants to engage in, is the same regardless of whether it's deceptive and it's behind her and she doesn't see it, or whether it's refusal and she knows what the accused is doing. Kirkpatrick kind of blurred the line because the judges disagreed about whether it was deceptive or not. So the reason this is a problem for sexual assault generally is that we are shrinking what a person gets to decide about the sexual activity they will engage in. The case you and Chuck I mentioned earlier, the Supreme Court said having control over who touches one's body and how lies at the core of human dignity and autonomy. And that statement has recently been affirmed by the Supreme Court of Canada in a case called GF. But when you go to a fraud analysis, the fraud analysis only works where there is a significant risk of bodily harm. And there are two contexts where we see that, where an accused person has HIV or an STI, and the issue becomes there's a risk of transmission. The other is where a complainant faces a risk of an unwanted pregnancy from the sexual activity. What worries me about this is that too many people are excluded from that formulation of the test. Lots of people are incapable of becoming pregnant because of gender, age, fertility, or the fact that they're already pregnant, for example. And I think it's really important that people have a right to insist on a condom for whatever reason they want. It shouldn't be up to the courts to say, well, your reason for insisting on a condom is not legitimate and somebody else's reason is. Having this risk of pregnancy be so significant also opens the door to cross-examining complainants on their personal health status. Are they capable of becoming pregnant, et cetera? And I think that's deeply problematic because sexual assault prosecutions are already so invasive for complainants. The minority judges in Hutchinson, so not the majority as Shakir was explaining, the minority said it's not a person's partner's business and it's not the state's business why you want to have sex only with a condom, and that we should leave it to that individual to decide whether they are willing to have sex without a condom. So I think what we're seeing generally is a shrinking of what consent is, or more importantly, what non-consent is, in the interest of legitimately not wanting to expand the criminalization of people with HIV. But what it's doing is shrinking the protection that the sexual assault laws provide outside of that context. So that's a very long-winded answer as to why I think this is important for sexual assault.
Well, that's very informative and helpful, Professor Grant. Thank you. If I can flip it over again to Khalid, you touched on a little bit about why HALCO and the network intervened in Kirkpatrick. Could you talk a little bit more about sort of what was argued specifically in those cases on behalf of those organizations?
Sure. So I'll just say up front that the position we took in the case during our oral submissions at the court hearing evolved from our written submissions, which had to be filed with the court earlier. So what I'll explain today is the position from those oral submissions at the hearing last fall. So we first said to the court that they should place condom removal or refusal under section 273 of the criminal code. And what that means is that whether or not a condom is used during sex is part of the physical sexual act, part of the sexual activity in question. So this is the part of sexual assault law that is not part of the fraud analysis. So 273 is about the sexual activity in question, and 265 is the provision that deals with the fraud analysis. And I'm just going to say those numbers because I might refer to them as I go through this. And so the idea is, and Chakra mentions in the introduction, but I want to repeat it for clarity, is that when one sexual partner states that a condom is a condition of their consent to sex, and then the other partner doesn't wear a condom, there would be no consent to the sex without a condom because it's a different sexual act than sex with a condom. So if condom removal or refusal is situated here under section 273.1, that's the consequence. We have different physical sexual acts when there's a condom or no condom. And we explained to the court that if they agreed with us that this was the correct route for them to take, they should specifically mention in their decision in this case that STIs, including HIV, do not form part of the sexual activity in question. And we already knew that that was the state of the law because that's what came out of Hutchinson and Maybeor and other cases, but we wanted total clarity on this. So we wanted it to be clear that HIV non-disclosure would stay under the fraud analysis under section 265. And while the fraud analysis being applied to HIV non-disclosure is still a problem in many of the ways that have already been talked about today, of the two main options before the court, our thinking was that this approach posed the least risk of expanding the criminalization of HIV non-disclosure. Because if this position was accepted, condom removal would be considered under section 273.1 as part of the sexual activity in question, and HIV non-disclosure would be considered and remain under the fraud analysis. The two areas of law would be separate, and so the decisions in condom removal cases would be far less likely to affect or expand the law that applies to HIV non-disclosure. Importantly, and as Isabel was just speaking about, we also felt that this approach better recognized the sexual autonomy of women in particular, and Indigenous and other racialized women in particular, and their right to be able to condition their consent to sex on the wearing of a condom. But we also knew that there was a chance that the Supreme Court might decide to keep condom removal or refusal under section 265, so to keep it under this fraud analysis. And if that happened, we still wanted to be able to explain to the court that they could do that and still ensure that criminalization of HIV non-disclosure was not expanded. So we had a second or an alternate position if the court didn't accept our primary submission. So we explained to the court that if condom removal stayed under section 265, this fraud analysis, it was very important that the court explicitly say that for HIV non-disclosure, there must be a realistic possibility of HIV transmission for fraud to be made out and for a conviction to occur, meaning that the current law that applies to HIV non-disclosure would remain unchanged and wouldn't expand. And the reason that this was important is that in the Kirkpatrick case and the facts that arise there, and in some other cases involving condom removal or deception, issues sometimes arise about the stress that the complainant felt because they were worried they might have gotten an STI, or the stress due to getting tested for STIs, and sometimes also because of the side effects of preventive medications like post-exposure prophylaxis or PEP for HIV. And we had a concern that if that kind of stress or those kinds of side effects were recognized as serious bodily harm, which is necessary to make out the deprivation aspect of the fraud analysis, as Shakir explained, that this could carry over to the HIV non-disclosure context. And there could be convictions even where there is no realistic possibility of transmission based only on the stress or side effects that a complainant experienced. And this was a big concern in our minds because we could imagine, for example, and this is not the only problematic circumstance, but this is one example, where a complainant might feel stress about the potential for HIV transmission or might take PEP and experience side effects, even where their partner is living with HIV, but has a suppressed viral load, so there was zero risk of transmission of HIV. If those circumstances could still lead to a conviction, people living with HIV wouldn't be able to know in advance what kind of conduct would lead to criminal charges or a conviction, And there could be convictions related to HIV non-disclosure, even where there was no chance, even zero chance of transmission of HIV. So we explained to the court what they would need to say in their decision to prevent that kind of broadening of HIV non-disclosure laws, or the laws that apply to HIV non-disclosure, if they leave condom removal under the fraud analysis. And we're waiting for the court's decision, so we'll see what they have to say. But that's an overview of the position we took before the court.
Thank you very much, Khalid, for that. Professor Grant, could you tell us a little bit about the Schleifer Clinic's position in this case, and also maybe touch on as well what you sort of see as the path forward given the different circumstances and contextual factors you outlined?
Yeah, we took a slightly different approach, but we thought it was an approach that is consistent with not extending criminalization of people with HIV. The Barbara Schleifer Clinic, that many of you know, works generally on violence against women, took the position that all condom removal should be dealt with, to use Khalid's language, under 273.1, right? That the right to decide whether to have sex without a condom remains entirely with the complainant, and that we don't need to get into questions of psychological harm and bodily harm, because that's fraud and that's something different. We think that condom, whether your partner is wearing a condom, is an essential part of the sexual activity in question to which you have to consent. And we didn't think it made a lot of sense to differentiate whether someone was standing behind you and you didn't see it, or standing in front of you and you did. And we thought that that was the most meaningful way to uphold what the court said in you and Chuck about the individual gets to decide how they are touched sexually. But we said that this is different than HIV, right? So we did give a path to the court to differentiate HIV non-disclosure. And we said it's different because the use of a condom is directly connected to how the sex happens. It either happens with a condom or without. Whereas HIV non-disclosure and deceptions about your HIV status is different because it's about the risks and the consequences that may ensue later on. And we think for the same reason that condoms deception is different than deception about, for example, the birth control pill. Because if a person lies about being on the pill, that doesn't affect how the sex happens. And so the Schleifer Clinic argued that we need to treat condom use as part of the consent inquiry directly related to the sexual activity in question. And I just wanted to mention one other small piece of what we were worried about with the Hutchinson decision. You'll remember that Hutchinson said essentially that the bare sex act is all you consent to. You don't consent to how it happens. You don't consent to whether there's a condom or there's not a condom. You just consent to, in that case, vaginal intercourse. That decision led an intervener group in the Barton case involving the death of Cindy Ledoux, an Indigenous woman, to argue that since you only consent to the bare sex act, you don't have to consent to how much force that sex act is carried out with. In other words, if you say, I consent to having someone put his fist in my vagina, I don't get to say with how much force they do that. Once you consent to the act, it's open season on the amount of force. And the Schleifer Clinic thought that was a really, really dangerous finding for women, particularly women involved in the sex trade, women in violent relationships, both of which are two contexts where condom deception happens a lot, but also the serious risk of harm, that women need to be able to say, no, you can't touch my body in that way. Even if they've agreed to a particular sex act, they get to say how they are touched and that is part of consent. So that's why the Schleifer Clinic thought it was really important to keep us out of fraud and into consent, both in terms of protecting the right of women to say how they are willing to be touched, but also in terms of just avoiding all the problems with the fraud analysis. And we think that's different than HIV, and we gave the court a way to say that it's different. And I will note that the Crown also in Kirkpatrick argued that it was different. right? The Crown was not seeking to extend HIV non-disclosure. They made very clear in their factum that this is different. This is about the how, not the risk of what's going to happen later.
Thank you. We have a question from the audience. I'm just going to paraphrase it slightly, but I think this is the central point that's being asked. What are your thoughts about whether there is valid consent without the disclosure of HIV status or an STI? Do we have valid consent, or can we have valid consent in those circumstances? And I'll start with you, Khalid.
I mean, I guess, you know, the question is, or there's a distinction perhaps if we're talking about valid consent under the law, or are we talking about consent more broadly? So I'd be curious to know kind of what that question goes to. I don't know if the idea is, do we want a clarification how that's analyzed under the law? Any thoughts on that, Shakir, about what might be asked there?
I think my thinking is, given we've been discussing consent in the legal context, maybe it might help to start off with that branch of it, insofar as the law is concerned in these cases.
Right. So under the law, as has been talked about today, HIV non-disclosure is analyzed under the fraud analysis of Section 265. And as Shakir took us through in the introduction, and I believe as Richard also spoke about, there are two elements, deception and deprivation. And so under the deception element, omission can be sufficient. So the fact that a person doesn't disclose their HIV status where there is a realistic possibility of transmission is sufficient under the law. So even if there's no kind of active misleading, there can still be deception so far as the fraud analysis applies to HIV non-disclosure. So to answer the question as I understand it, if someone doesn't disclose their HIV status to a sexual partner in circumstances where there is a realistic possibility of transmission, the idea is that consent is invalidated under the law. And then of course, there's all sorts of critiques about whether that should be the case. And I think generally, as we kind of heard about the ideas of reforming the criminal law as it applies to HIV, most advocates and communities of people living with HIV say that that's not the right balance. And at the very least, we should move towards a position of criminalization only where there's actual and intentional transmission, and some would call for going even further than that.
Yeah, I'll just add to that a little bit, if that's okay. And that is to say, we don't in criminal law have a standard of informed consent in sexual assault. That is not the test. So you're probably all familiar with it. You know, in a medical setting, you have to understand the risks and the consequences and all of that. We don't have that standard in criminal law. And I have some difficulty with that outside of this context, right? I think a person should understand that engaging in particularly unprotected sex with another person does have some risks. But I think as long as we've got HIV in the sexual assault box, we can't go there. And I think that's another reason why the development of HIV non-disclosure is really hurting the development of sexual assault law generally. We could explore those possibilities if we took HIV out of sexual assault, but we can't even open the door to an informed consent standard in criminal law generally because of the, you know, the discriminatory prosecutions that we've seen and that Richard and others have outlined for us earlier today. So our understanding of consent is very narrow in criminal law, and I think it may need to be broadened, but we got to get HIV out of there first. Otherwise, we can't go there.
Okay, thank you.
Maybe I'll just echo something there that of Isabel's comments and part of kind of our thinking in this case. That was a real tension that we encountered as part of thinking through this case, thinking through kind of the evolution from Hutchinson to Kirkpatrick, and Halco and the legal network intervened in Hutchinson as well. And there we took a different position before the court. And in part, we took a different position because the law was a lot less clear at that time. There wasn't any previous Supreme Court case law that dealt with condom removal or condom refusal. And so we couldn't really predict how things would unfold based on what the court decided. There was a lot more risk of HIV being more heavily criminalized. And this time around in Kirkpatrick, we had this previous case law, and we were very alive to these tensions, to the fact that so long as HIV is situated under sexual assault law, the analysis of consent in some ways can be limited. And so that's what we were trying to think through. And that's in part why our position evolved from when we submitted our written submissions to the court and what we said in oral submissions.
And one of the things that's been really nice for me to see over the last decade or so is how the HIV community and the feminist community outside of HIV have kind of come together, right? A decade ago, you might have seen the feminist community arguing for a more stringent approach that would result in overcriminalization. But I think over the last decade, we've seen a real kind of rapprochement between those two organizations, that the HIV organizations recognize the importance of maintaining the protection of sexual assault law, and the feminist organizations recognize the importance of not overcriminalizing people with HIV. And I think that's been a really important development.
Well, I think that brings us just to the end of our time today. I want to thank both of you for your thoughtful and considerate remarks today. And I think it highlights just how much of a mess placing HIV under the sexual assault framework has made of so many sort of equity type objectives that we're all trying to seek under the law that are being hampered by this approach. So thank you both. And we are now going to have a 10-minute break until the next session begins.
Welcome back to the symposium, everyone. I hope you all had a chance to stretch your legs and get comfortable for the last panel of our symposium, HIV Justice Worldwide, Global Movements to Limit HIV Criminalization. The panel will be moderated by our dear friend, Edwin Bernard, founder and executive director of HIV Justice Network, a global information and advocacy hub for individuals and organizations working to end the inappropriate use of the criminal law to regulate and punish people living with HIV. Over to you, Edwin.
Thanks so much, Sandra. And it's really a pleasure to be with you all today. So as Sandra said, I'm the executive director of the HIV Justice Network. We're based in the Netherlands, working internationally, and I'm also the global coordinator of HIV Justice Worldwide. So HIV Justice Worldwide is a global civil society coalition that campaigns to abolish criminal and similar laws, as well as policies and practices that regulate, control, and punish people living with HIV based on our HIV positive status. And it was founded in 2016 by 7 organizations, including the HIV Legal Network, and it's now grown to a 14-member steering committee with 120 member organizations. And the contribution of the HIV Legal Network and other Canadians, including activist academics, community legal organizations, and members of the Canadian Coalition, to the global HIV justice movement is immense. Your advocacy in Canada is often groundbreaking, but it's also heartbreaking to hear that even with these brilliant collective efforts over many years, that many Canadians living with HIV still feel unsafe. So I'd like to recognize the unwavering dedication of Canadians to improve the lives of people living with HIV around the world. And in this final symposium session, I'm going to be speaking with 3 brilliant leaders in their respective fields about their work to achieve HIV justice worldwide. Don't forget, if you have questions for them or for me, you can post them in the Q&A box. But first, we'll start with a video that launched an important new briefing paper published last October by HIV Justice Worldwide to support people living with HIV, activists, legal experts, and human rights campaigners to understand the complexities and the consequences of molecular HIV surveillance.
Molecular HIV surveillance, MHS, is a growing research and public health surveillance practice that has concerning implications for human rights. It uses blood samples taken from people living with HIV during routine drug resistance testing, and then stores these samples in surveillance databases, so that they can be used for public health purposes. Some people consider this to be an exciting new public health tool that can help identify HIV transmission hotspots and ultimately end the epidemic. So why is it that HIV activists are so concerned about this new technology?
Even though molecular HIV surveillance can be a useful public health tool, it's often done unknowingly without consent.
It's been rolled out without any community involvement or engagement.
Surveillance is often linked to the policing of our communities, where Black and Brown people are disproportionately targeted.
When you combine MHS with HIV criminalization, it's a perfect storm.
Molecular HIV surveillance, MHS for short, is an umbrella term that describes how scientists and public health practitioners analyze the blood samples of people living with HIV to track how the virus is moving between people and populations. MHS can detect patterns of transmitted drug resistance or rates of HIV transmission in a given area, but it can also identify groups of people with similar strains of HIV and link them together. Some scientists and public health folk argue that this approach can be used to link hard-to-reach people to testing, treatment, and care faster than less problematic tried and trusted methods. But a growing number of human rights activists, including people living with HIV, have deep concerns about the ethics of MHS and believe it may do more harm than good to both public health and human rights.
Our global review revealed many concerns on the practices of MHS, most specifically concerns arising in the context of public health, where data is being collected on people living with HIV without their knowledge or consent as part of a public health surveillance system, and then used to inform public health interventions. This is taking place in countries which actively criminalize sex work, drug use, migration, and HIV, and where data about HIV transmission networks is being shared in unprecedented new ways that is intended to identify people. Sometimes public health institutions will then share their data with researchers who conduct even more analysis on people without their knowledge or consent.
The list of our concerns is long. To name a few, many people do not consent to having their data used in any other way outside of informing their doctor to receive better care. MHS research, public health surveillance, and public health intervention occur without explicit consent from people living with HIV. This means it's increasingly important we have community consultation and engagement to mitigate potential social harms. MHS is frequently applied to already marginalized and criminalized communities. This includes gay and other men who have sex with men, trans women, sex workers, people who use drugs, migrants, and people experiencing houselessness. Public health agencies have historically shared their data with researchers, and funders of this kind of research often require the resulting data to be made public. The issue of trying to prove direct transmission is controversial and is addressed by many researchers with widely varying views. The science behind direct transmission is still contested, and there's concern that such analysis is harmful if it is misused and misunderstood in HIV criminalization cases. In every jurisdiction in the world, even where health privacy laws exist, MHS data, along with other medical records, can always be subpoenaed by a court and used as evidence in criminal investigations or court cases. That means if MHS evidence were included in an investigation or trial, even if the results only inferred that the HIV strain of one person was older than the strain of another, but the limitations of this evidence were not clearly explained and understood, this could actually suffice for a conviction.
Just like with HIV criminalization, MHS assumes that people living with HIV are solely responsible for HIV prevention, that we're just clusters and targets of public health interventions and not the beneficiaries of public health. We are people, not clusters. We are the public too. And that's why, as global coordinator of the HIV Justice Worldwide Coalition, I commissioned Positive Women's Network USA to produce Molecular HIV Surveillance, a global review of human rights implications, as a first step to understand the problems and to suggest a range of possible solutions.
The main aim of this briefing paper is to help support people living with HIV, activists, legal experts, and human rights campaigners in understanding the complexities and consequences of MHS.
We start with a detailed explanation of what MHS is and then how it is used across the globe, including how the technology works, where it is being conducted, and by whom. The report then describes the growing human rights concerns relating to the use of this technology and goes on to list a number of recommendations for the use of MHS, which were gathered from a survey of international literature and from members of our expert advisory group.
Go to hivjusticeworldwide.org/MHS, where you can download the paper, Molecular HIV Surveillance, a global review of human rights implications.
Get others engaged, and not just from the HIV sector, but also from other movements, such as other health areas and the data privacy movement.
Let's start a conversation here, online, or elsewhere. Hashtags NMHS, HIV, HIV Justice, Data Privacy.
And very soon, let's get together and strategize.
So I'd like to welcome Alexander McClelland, who, along with Alfredo Trejo, was a co-author of the paper. Welcome, Alex.
Thank you so much to the Legal Network for having me. Excuse me, sorry. Good to see you, Edwin. How are you doing?
It's good to see you too. So just to say that the paper is available not only in English, but also in French and in Spanish and in Russian.
That's wonderful.
But let's talk about why molecular HIV surveillance is a concern for people in Canada.
Yeah, it hasn't gotten as much attention in Canada as it has other places. And I think that's a great, the paper that we developed is a really great tool for activists in Canada to start understanding some of the implications. But molecular HIV surveillance originated in BC. I think it was one of the first jurisdictions to roll it out in terms of how the system works. And the BC Centre for Excellence there has been doing it for quite a number of years. Quebec is also doing it. And there's a number of concerns. I think, interestingly, there's been a massive movement of people living with HIV responding to the use of molecular surveillance in the United States, and people actually called for a moratorium on the use of molecular HIV surveillance because of the concerns around violations of consent, lack of community engagement, violations of rights of people living with HIV. And that moratorium actually worked. It got researchers in the US to stop a massive NIH-funded study, which was repurposing data that the researchers had got from public health authorities in one specific state that was collected without the consent of people living with HIV. And the researchers understood that that was a violation and they could not conduct that research. Yet in Canada, many universities are doing this research where they get data from public health departments who are collecting data on behalf of the state. The University of Montreal, McGill, University of British Columbia, Simon Fraser University, just to name a few, have been doing this research for years, where they get anonymized data from public health, and they do all these various different analyses. For example, there was one study recently done looking at the country of origin of infection for people moving into Quebec. And the study outlined that the country of origin of infection was from Haiti for men having sex with men. And this is in the context of a country and province which is rife with anti-Black racism and extremely xenophobic. And not once did that paper outline or address the potential concerns of how that study could impact Haitian men in the province. And it didn't even address the issue of HIV criminalization. And so this research is happening in Canada. I think the HIV movement needs to know about it and know what's happening. And we should expect that it will roll out here probably across the entire country, as it is happening around the world. It's now like a requirement in PEPFAR funding that countries roll out an entire molecular HIV surveillance system across their country. So I'd be quite surprised if other provinces don't start following suit. And we should be continually looking to the US and movements of people living with HIV in the US for their leadership, and also your leadership internationally around how to address and respond to this issue. So I think one of the things people can do in Canada is get a sense of what's happening here, what studies exist, and what are public health departments doing. And so in Quebec, public health departments are sharing data with researchers. And interestingly, one of the concerns is a data sharing concern with this issue, because public health departments will share data with researchers, but also the genetic sequence data only becomes interesting once it is paired with a whole bunch of other demographic pieces so that we can understand the social context of that genetic sequence. They want to know lots of stuff and try and connect lots of different data sources together. And there's this myth that's told that it's all anonymous, that no one knows who these people are, but that's actually a fallacy. The entire purpose for public health departments to do this is to identify people, to intervene in clusters, and to go and find people and to get them connected to care. And in a context of criminalization, this could be quite concerning. And also in a country that has actually used genetic sequence data in one of our most famous and high-profile cases, where a man was prosecuted with first-degree murder, there was genetic sequences used as evidence in his court case, or in his trial, as contextual evidence that proved that his country of origin of infection was in Africa, and the women that he infected were white and could only have gotten HIV from someone who had HIV from the region in Africa that he was in. And so it's been used in trials already. We are one of the leading countries in the world to roll out HIV criminalization, and also innovated this HIV prevention surveillance mechanism. And so I think we should be quite concerned and be working more collectively to figure out how to respond.
Thanks so much, Alex. So that's all the time we have to talk with you about it. But I'm sure that the HIV Legal Network and the Canadian Coalition will be addressing this. And thank you for your leadership on this too. So for now, Alex, thanks so much.
Thank you. Good to see you.
Same here. But now I'm delighted to welcome two brilliant human rights lawyers on staff at the HIV Legal Network, who work closely with the HIV Justice Worldwide Coalition, focusing on two of the world's HIV criminalization hotspot regions, Cecile Kazachkine and Mikhail Golichenko. Welcome, Cecile and Misha. Misha, we'll talk about your work in the EECA region in a moment, but first I'm going to talk with Cecile. So, Cecile, you've been instrumental in building a French-speaking network across West, Central, and Northern Africa. And there are many HIV-specific criminal laws in the region, but we are seeing some positive developments. Can you tell us about what developments are happening in the region?
Hello, Edwin, and hello, everyone. It's really a pleasure to be here with you all and to see you, Edwin. So yes, indeed, we with the support of HIV Justice Worldwide, we've been able to create this space dedicated to Francophone activists on HIV criminalization. And that space, provides Francophone activists, with a forum to discuss and exchange their experience. But it also goes beyond, because we are also able to provide some technical and financial support to local advocacy in a Francophone country, including especially in Africa. And And I think that's really good, because we can, beyond mutual learning, we can actually all together be actors of change. And so one example of work that we've been doing is for several years now, we've been supporting civil society in Burkina Faso as they've been working on trying to reform their HIV law there. And as you mentioned, Edwin, advocacy in the region often focus on reforming HIV laws, because there are many legislation, HIV legislation, supposed to be protecting people living with HIV on the continent that actually have very problematic criminal provision in the legislation. And so, for example, in Burkina Faso, the current legislation, impose a duty to disclose. It also imposes a duty to abstain from unprotected sex, and it has like several provisions criminalizing exposure or transmission of HIV. And just having unprotected sex without disclosure is considered as voluntary transmission, even if you had no intent to transmit or if you did not transmit. So that's the current legislation in Burkina Faso. So our support to civil society there has been just to provide them with the means to be able to meet, to talk about how to amend the law and what amendment and what would it mean for them, and to strategize and to also meet with some important stakeholders, including religious leaders, as well as policymakers, and promote the international expert consensus statement. And I think those efforts are paying off. Like we've seen a bill drafted that actually does not include any criminal provision in the new HIV bill. So that's basically decriminalizing HIV. And there is also a specific provision that describe what would be voluntary transmission, and they describe it as something that would be like intentional transmission. So even if another piece of legislation were used to criminalize those type of acts, at least it would be more circumscribed. So I think that's an important advancement. I was unsure about where this would go because there's been a recent coup in Burkina Faso. So of course I didn't know what's going to happen with our advocacy, but I had some exchange actually by email today with groups there. And they say they've already met with the new Ministry of Health, and they're going to continue pushing for this new legislation to be passed.
That's amazing. We don't have an awful lot of time, but I'd love to also know, because one of the benefits of the network is that you can really respond very quickly to unforeseen challenges. And I know that was the case with a recent law in Benin. Can you just very briefly explain what happened and how you're hopefully making a difference?
Yeah, so the situation in Benin is a bit different because basically we've been supporting civil society there to try to prevent a bad law to pass. So that's the beauty of a network is we were informed by UNAIDS colleague in West Africa about a new bill in Benin to reform the HIV law, and it contained a lot of problematic provision, including possibility for forced treatment of someone who would be considered as posing danger to others. And with HIV Justice Worldwide, we were able to actually mobilize a network of people living with HIV in Benin, representative of key population, and also bring other experts that are part of our network from Niger and also from DRC. And we all came together to discuss this problematic legislation and try to strategize. And I'm quite hopeful with the process because I know that the text has been revised, but now I just don't really know if a new improved law will actually go through the legislative process, but at least we've prevented a bad law from moving forward. Well.
Thanks. Thanks for giving us a couple of examples of the incredible work that you're doing across Francophone Africa. So if you've got any questions for Cecile, please post them in the Q&A box. But for now, thank you very much. So let's turn to Misha, because in terms of HIV criminalization, the Eastern Europe, Central Asia region is the global hotspot. In our most recent analysis, it was Belarus, Russia, and Uzbekistan that were the top 3 countries for unjust arrests, prosecutions, and convictions in the world. But even in difficult political, social, and legal environments, incremental improvements are possible. So tell us a little bit about the work that you're doing there, Misha.
Thank you, Edwin. Good afternoon, everyone. As Edwin rightly said, Eastern Europe and Central Asian countries, unfortunately, is a hotspot for HIV criminalization. Just to put you into context, in Russia, only in Russia, a country which is 3 times bigger in terms of its population in comparison to Canada, we have over 1,200 cases since 1998. That's the huge number of cases. And just for you to understand the justice peculiarities in those countries, if police charges somebody with HIV criminalization, the chances of acquittal are very close to 0. So it's very sharp knife police has in their pocket. And if they start prosecuting person, the harm is almost imminent. So our work there stems from the reasoning that the countries are sharing common legal history and legal traditions. And often countries just copy past Soviet laws and just transmit them into their renewed codes. Such was the case with Kyrgyzstan or Kazakhstan, which undertook legal reforms just recently. But unfortunately, when it came to HIV criminalization, all laws remained intact. And there was a very strong opposition in the parliament majority, despite the initial willingness to go for certain mild reforms in the beginning. So our strategy of working in that countries consists of 2 major directions. Both are to support communities of people living with HIV and other key populations, and also work closely with regional and national partners, also work with the UN agencies there. Huge support by UNDP and UNAIDS. And of course, HIV Justice is a great network which is supporting the movement. So direction number 1 is the law and policy reform. And the example of good work in this area is the recent amendment of criminal code in Belarus, where Belarus introduced the, although kind of weak, but still useful exception for people living with HIV, which means that they are exempt from criminal liability if they inform their partners about their status in advance. Believe it or not, before that, regardless of whether or not you inform your partner, if you have an unprotected sex with partner, you are still considered criminally liable. And there were many cases which would deal with such situations. And another quite positive development still in Belarus is the commitment of law enforcement now to go for the adoption of the guidance for prosecutors on HIV criminal cases. We are working together with HIV Justice Network and UNDP there in Belarus, although the country is extremely difficult to deal with. And I don't want to go into the context, but it's just difficult to work through and through. But there's a certain commitment from law enforcement, and hopefully by the end of this year, we'll have good result in adopting the guidance to the national context and the context of Russia. So there would be 2 countries mostly affected by HIV that would benefit from the adopted guidance. And second direction is to advocate internationally through litigation and through submitting shadow reports to country reviews at human rights treaty bodies. For the last 3 years, we secured strong recommendations for such countries as Belarus, Uzbekistan, Tajikistan, and Kyrgyzstan from different human rights treaty bodies. Those recommendations are instrumental in applying certain international pressure on the national bodies and parliaments in order for them to start thinking again and again
about the legal reform. I would end up with the notion that, of course, the current situation with the outrageous criminal invasion of Russia against the Ukraine, and both countries, I consider them my home countries. Half of my family is from Russia, half of my family is from Ukraine. Both countries are basically in a very, very deep humanitarian crisis. This is going to affect our work for the years to come. I wouldn't go deeper into this, but just to make sure that, yes, we all are aware of the situation and we monitor closely what's going on there. But, well, we can only expect better from this very difficult, terrible times. Thank you, Evan.
Thanks, Misha. I mean, of course, Putin's invasion of Ukraine, there is a humanitarian crisis, and obviously not only for people living with HIV. And as you say, we're working closely with our partners in the region, and particularly with the Eurasian Women's Network on AIDS, EVNA. So whilst I'm waiting for some questions for us, really, do you have it? I mean, I think now is the time to talk about that elephant in the room. How given there were already challenges before and there were incremental improvements in various parts of the region, but how we're going to work in Ukraine, in Russia, in Belarus, in the context of this humanitarian crisis?
I'd start from what to expect, I think, and I'll do it in a brief way, but I think that the war in its active phase will end by the end of April, and Ukraine will then recover quickly, except certain regions. But Russia is going to sink into a very likely civil war scenario with a huge humanitarian human rights crisis. So for our work, that means that I think we won't be able to do anything meaningful in Russia with respect to HIV criminalization. But the good news is that police will be busy with arresting civil society activists that are protesting against war rather than HIV, people living with HIV. In Ukraine and many other countries, maybe including Belarus, the activities to prove that they are not like Russia would be growing, and that's hopefully will concern HIV laws too, because many repressive laws are coming from Russia. Hopefully will have some new movement among countries around Russia to prove that no, we are not like Russia, therefore we won't have legal reforms, including to decriminalize HIV, decriminalize drug possession, and so on.
So I'm just checking to see if there are any questions from the audience, and there aren't. So perhaps I can bring Cecile back, and because I'd like to we've worked together for a long time, and Misha, we've worked together more recently, and I'd just like to get a sense of what you think the contribution of the work in Canada, as I said in my introduction, the incredible work in Canada that you've been doing for so many years, how that relates to the work that you're doing internationally. Cecile, you began by working on domestic Canadian issues, and now you're focusing very much on work internationally. How has that helped in moving forward with the work?
Good question. I hope it helps a lot, actually, because I've been working so deeply on HIV criminalization, and I've been thinking about this issue, in so many different ways, that I think it helps me when I discuss with others in other situations to see some pitfalls of maybe one or another strategy, and be able to provide some recommendation as to if you go this way forward, think about these negative consequences or negative impacts this may have, we've also brought some of the learning from our Canadian advocacy into the international sphere through, for example, our work with scientists. So you may remember that in 2014 we developed this Canadian statement on HIV and its transmission to explain, present the data on HIV and its transmission to scientists, by scientists to the members of the judiciary. And then we did this again, but internationally with experts from around the world. And I think this statement that is international is having a big impact. And I know that, for example, in Burkina Faso, it has really helped with people understanding why they need to get out of HIV criminalization, why it doesn't make sense.
Thanks, Cecilia. And Misha, for you also, having worked in Canada, how does it help?
It's, I mean, the example of how not to use the general laws against people living with HIV, that is an example from Canada with good documented negative consequences. The legal network, Canadian HIV Legal Network, has many briefs which I use in the region. The consensus statement, which Cecile mentioned, although international, but we all know from where it came initially as an idea, we use that all the time. And the recent case we had in Uzbekistan, which started last summer, we actually used this statement as a strong evidence for the forensic expert to rely upon. And the guidance, the prosecutorial guidance, is also came initially, as far as I know, from here, from Canada. It started, the legal network and partners started developing this, correct me if I'm wrong, and then it became an international tool. And now the idea to adopt it to Belarus and expand to Russia at least is also a good scenario to mitigate the adverse consequences of HIV criminalization there, which relies on the experience here.
Thanks, Misha and Cecilia. So over now to Sandra, who I think has some questions for us.
Thank you, Edwin, and thank you, Richard, for popping some of those resources in the chat box. There's a question I think that all three of you could potentially answer, and answer brilliantly. It's a question from Allison about countries in either Francophone Africa or EECA that are more influential or leaders in terms of other countries following their policy. She's wondering about strategic focuses for advocacy and support in order to catalyze change. So I'm sure any one of you could maybe Edwin could start with taking a stab at this.
Well, obviously, Cecile and Misha are the experts in their particular regions, but I mean, one of the things that's I think we should be celebrating is the fact that Zimbabwe, which was the first country on the African continent to pass an HIV criminalization law in 2001, has just repealed its law. And it's the first time that parliamentarians in an African country have made that decision. There have been other ways that laws have been repealed and improved, but this is the first time. And although Zimbabwe is quite away from Francophone Africa, what's interesting is, of course, is that the laws in many of the laws in Francophone Africa were part of a USAID model law that actually ended up infecting the entire continent. So perhaps this positive news from Zimbabwe could actually impact some of the countries in Francophone Africa and maybe even beyond. I mean, it's a remarkable achievement for the movement to end HIV criminalization. But Cecile, I mean, in terms of Francophone Africa, are there countries that you think are leaders that where change can be followed?
Yeah, I will not get into like geopolitics. I don't know how you say it in English, about like what country will influence others. I may not be enough of an expert to do that, but for sure there have been some, some improvement in several countries in Francophone Africa regarding the HIV law. As you said, Edwin, it all started with this bad model law in 2004. That really expanded through the continent. But since then, we've seen other countries that have adopted later in the game some HIV laws that have actually provisions that are much more limited. For example, I think it's Congo that actually limits really strictly criminalization to intentional transmission. I think, and to go back to what Misha was saying, this is like a good example of how having an HIV specific law sometimes can help, circumscribe the scope of the criminal law, and we see in the region that often the efforts are not necessarily to completely repeal HIV criminalization provision, but could amend them so they are really strictly applied. And we've seen a series of those happening.
And for Misha, it's clear. It seems to me that Russia is the influential country in the region, but perhaps you can explain how maybe some other countries in the region could be taking the lead.
Yeah, it's always been Russia in both good and bad senses. And when it comes to HIV criminalization, what happened to Belarus back in 2019 when this amended law came into effect with the exemption, the similar exemption was introduced and adopted in Russia back in 2003, and a huge piece of advocacy was very much about how Belarus could become at least as less repressive as Russia. But also Uzbekistan, for example, now have the community, legal community in Uzbekistan has a powerful judge from the Supreme Court who is strongly advocating for the reform, and his voice is loud despite the fact that he's from Uzbekistan. So I guess now, and that's the idea behind the regional advocacy rather than a purely national advocacy in EECA region, where we have positive development in many of those countries, we can actually cross-fertilize our advocacy in other countries, regardless the fact that some countries have de jure or de facto the state of war, like Russia and Ukraine. Since 2014, the de facto war states were still using examples from each other and we use that examples for advocacy.
I think one of the things that that you and I participated in recently, Misha, was a judges forum that UNDP convened, and I was really impressed by the engagement of the judges in that region. And what was interesting is that it was inspired by a regional judges forum that was an African judges forum. So there are actually links there. UNDP is doing great work convening them. But in terms of the judges across the EECA region, which countries do you think have the best engagement and understanding of the problems that we're highlighting here?
Ukraine and Moldova, of course. But because both countries are doing right things in terms of developing democratic institutions, and courts are powerful institutions who are more and more open for the ideas to reform laws and policies, and therefore judges are not only receptive to new ideas, but they are ready to promote something they really believe is a good way forward. So Ukraine and Moldova, and I strongly believe that Ukraine and Moldova would be two countries that would propel the region forward when the war comes to its end.
Well, let's hope that's as soon as you were saying, Misha. Well, for now, well, actually not for now, but for the whole afternoon. Thank you, both of you, Cecile and Misha, and of course to Alex for speaking with us earlier. I'm going to pass the baton back now to Sandra.
Thank you, Edwin, and thank you to Alex, Edwin, Cecile, and Mikhail for this wonderful panel. We really appreciate hearing your perspectives and global perspectives, as we know there's a lot of solidarity work we can do in Canada and around the world. So I just want to close by saying thank you to all the panelists, the positive women contributors, and to Maria for sharing your lived experience, your incredible work, and your tireless advocacy against HIV criminalization. You're all an inspiration. Thanks to our interpreters, our phenomenal producer, Nicholas Feustel, all the legal network staff, including everyone who worked behind the scenes, Terry, Megan, Sean, and Doriana, to make this event a success. And thanks to the Public Health Agency of Canada, whose funding made this symposium possible. Thanks also to the audience, to you for your care and attention to this issue. We're grateful for your solidarity. I'm going to pass it over to Janet now for some final notes about wrap up.
Yeah, I echo, obviously, Sandra's thanks. It's just been a phenomenal afternoon of learning, I hope, for all of us. We're wondering if you have a few minutes, if you could complete the post-event evaluation. It's a learning opportunity for us at the HIV Legal Network, and also really important for the funding that we receive to produce these symposia. There's a link in the chat. You see it up online right now in both French and English, and this information will help us to evaluate our work and really ensure that our events are relevant and useful. And we're going to thank you in advance for your thoughts. You'll receive an email after the event if you missed the link, so don't worry about that. And I should also say that recordings of the symposium are going to be available online shortly, and we're going to produce a summary report in the coming weeks. And we're hoping you'll watch our website for details. Thank you again so much for being here with us today. We're grateful to all of you for engaging in this critical discussion on HIV criminalization in Canada and beyond, and we really wish you a restful afternoon and evening. Thank you.
Thanks, everyone.